how we were going through that. So we'll have time to talk about those again, and then we'll be able to vote on everything, and we'll be done within 2 hours. So with that, let's go to 6, and that should be on the screen. And what are the pre-submitted comments on 6, Alex?
So we had a comment from Roxanne and her colleagues at the NLRB asking about the timeline for proactive disclosure in this section. And then we also had a comment from Burke and his colleagues at the FTC regarding the expedited processing and disallowing fees.
Okay, so let's hear from Roxanne first, and then we'll hear from Burke.
Well, I believe this actually may have been submitted by my colleagues. I think they just basically wanted some clarification as to if we're going to have a requirement, what's the time frame requirement for making the posting such that we would not get in trouble for not doing it properly. But that's my guess. This was not actually my comment, so apologies.
Sure, that's fine. Okay, and then let's go to Burke, and then we will talk about it. So FTC.
Yeah, so I think our comment was just, some of these procedures that, if an agency has been found not to have disclosed something affirmatively that should have been done, now, there's an expedited processing requirement, and now there's no opportunity for fees. And I think our feeling was this seems somewhat punitive, actually, for agencies that are, doing their best in terms of making disclosures. And so I would suggest not imposing any different or more stringent requirements on processing affirmative disclosure requirements than a normal request.
Okay. All right. So let's do this one at a time. Let's do timeline, and then we'll do if we want special procedures. Would anybody like to be heard on the timeline? Let me look through first, see if we have committee members. If not, then I'll call on you, Alan. Seeing none, Alan, the floor is yours. Alan Morrison.
Yeah, had to unmute. Thank you. So I want to side with the agencies on this in two respects. First, it doesn't make sense the way it's written, because you don't know whether they were legally required to proactively disclose the records until you adjudicate that in the court proceedings. So how can you know that's the condition under which there's expedition? The second thing is, I don't think that the processing generally ought to be like 552 A3. This is not an individual record. This is much more like an APA challenge, which is, I've argued in other places, this ought to be to begin with. And so it's one thing when a particular record is not disclosed that you need it right away for expedited processing, but these are things that have been going on for a long time. And if the agency's made a mistake, it's made a mistake, it hasn't done it, or it's done it whatever reason. So it seems to me that this has got it wrong, that there should be no expedition in my view. There's no reason to have expedition in these cases. Indeed, there are probably reasons not to have them, because they're important questions that should be proceeded. The agency should have an opportunity to have a look at them. And the second is, it shouldn't be conditioned on the fact that you have to decide something which you were going to decide in the case. There's a basis for expeditious recruiting. And as far as charging the records are concerned, I mean, this is not a big duplication request. These are things which they have duplication. These are the question is whether they should be put up on their website. I just think the problem, of course, is that we've forced the mandatory disclosures into A3 when they don't fit very well. These are much more like APA cases. And maybe rather than trying to rewrite all of this stuff, just simply to say that, but I don't know what to say about the procedures, but trying to rewrite procedures now is going to be very difficult. Anyway, so I want to go on the record as saying I'm supporting the agencies on this thing, and let the record reflect that. It's not happening very often, but it happens once in a while. Thank you.
Okay. But I hear that. I'm just trying to think what we should say instead. Do you have thoughts on what we would say instead here? To take a second while you're thinking about that. I'm going to ask Margaret from our consulting group for some thoughts, but I'll circle back to you, Alan. Consultants, Margaret, what do you think?
Sure, yeah, and before I respond, I just wanted to clarify for everyone here that in advance of this meeting, the consultants were asked to speak with one voice. So I am attempting to speak on behalf of everyone in the consultants group, and we'll do my best to do that. So that's why you might not hear from others as you have before. So a couple things. One is our thinking on this was that this would essentially, if there were materials that were supposed to be put online, those would already be available both immediately and with no cost. And so if they weren't, that if someone made a request for those same materials, it should be available as quickly as possible and with no cost. So this is not an effort to be punitive, but rather an effort to assure that a person who has a need for those materials that were already determined to be, of such an importance that they are supposed to be proactively disclosed, that person would be able to obtain them, on an individual basis without having to bring sort of a big pattern or practice case, the way Alan is describing, that they could simply make a request and they would essentially get the benefits of that sort of prioritization without, even if the agency hadn't managed to get to its affirmative disclosure obligations at that point. On timing, I think we did not discuss that at length. I will say that's something that probably could be addressed in an agency's affirmative disclosure plan to some degree about how they're going to do their affirmative disclosures under our sort of global view of this, but it's not something we had a strong view on, and I certainly don't think there would be a problem, inserting some sort of deadline generally for these new obligations to the extent that there are some that are not yet in the law. So I think with that, I'll say, I think, most requests go without charging fees anyway. So I don't think that this is likely to have a huge impact, but in the event that there were fees, these are records that are supposed to be disclosed. And to some degree, all of these decisions, expedited processing, fee waivers, things like that, are agencies guessing what judges would do in those situations anyway. So I'm not sure I agree with Alan that that there's some different kind of exercise going on that would require judicial review. So if there's any other questions, I'm happy to answer them.
All right, I'm jumping the line, putting myself in the queue, and then I'm going to call on Ted Hunt. I think on the when point, that's actually really important. I don't know if it needs to be here because it's broad. It's for the entire, all of them. It's when do they go into effect? I don't know if we necessarily even need to say that. I mean, I think we could cover that in the preamble or whatever, we send over to Congress saying, the implementation timing is a question that we have not addressed. Presumably we would give all the agencies a year. I'm just like spitballing it, a year or something to get on board, but that's not something that we have even covered because it's not really, we're talking about something that's going to last for, generations. The initial transition period is something that isn't necessarily what we need to even talk about. Maybe I'm wrong about that. Ted Hunt.
Yeah, I mean, I agree with Burke and Alan's comments because it seems like this is kind of putting the cart before the horse because it's basically based upon the request. So the request may or may not have merit, and maybe there's a reason why that this actually, what's been requested, actually doesn't fall into the categories of what needs to be proactively disclosed. So essentially, we're being told, agencies being told that, well, you have to treat it as expedited, and you can't get any fees no matter whether it has any merit or not. So that's why I think it just, for me, it just doesn't work. I'm not sure the solution, what the exact solution would be here. But that's where I think it falls out for me.
I mean, so if I'm hearing you, I'm just, again, are you saying like just delete the second sentence of recommendation 6?
Yeah, I mean, but if you take that out, what does the rest of it say, though, is my question. It doesn't really say much. I mean, I guess you can say that use the procedures under 552A3.
Yeah.
That's kind of it. Yeah, I mean, it's just, that's the issue, is that it's presupposing that the agency's made a mistake. And so just based upon the request only, you have to expedite it, put it at the front of the line, and you can't get any fees later. I just kind of feel like, well, those types of things, it depends upon whether there's actually some merit to what they're asking for.
Okay, Roxanne, then I'm going to circle back to Alan.
Yeah, I was just, thanks. I was just going to say that I think the concern that my folks have is that if this is, as you said, an ongoing obligation for generations. And so if the agency creates a document that it qualifies as a legal material that needs to be posted, how much time do they have to post it before they're subject to these
Oh.
types of claims? And so is it immediate? Is it 1 week? Is it a month? Is it 3 months? Is it 6 months? So say reasonable is 3 to 6 months, and somebody files a claim, 2 days after the document's been created, and now you're jumping through hoops because you have to give that expedited review. Meanwhile, everything else you're supposed to be doing is getting backed up. I think they're trying to figure out what's a reasonable time frame for posting of these documents. I can say I recently had a situation where we had to update our website because of a court decision that affected some rulemaking that we did. And we wanted to change our website, what it was saying about that rulemaking. I'm embarrassed to say, took 2 months to get agreement from the folks in our agency as to what the new language on our website should say. It was something that should have changed immediately since a court had slapped our hands about something, but it took us 2 months to post information. And so it's sometimes, unfortunately, agencies' wheels don't turn super fast.
All right, I'm going to call on Alan, but while I'm doing that, Margaret and the consultant groups, can you guys kind of just think among yourselves what a deadline would be, 90 days or something that might be useful? If you don't know, that's fine, but just that's a fair point. We should have some sort of deadline. I don't know what it is. So
I'll say
if
we
you
had
guys-
a quick
Sure.
conversation before this call, and 90 days came up. So I think something like that does feel like it would be reasonable, because it isn't a question that we had addressed thoroughly.
Okay, Alexander, put 90 days up there as a placeholder, and then I'm going to call on Alan. Alan, please.
So I now realize that the first sentence can be fixed. The Congress should provide that a person may use the process when the person alleges that the agency is required to post it. In other words, you can use the process when that's the allegation, and I think that takes care of the problem that I had before in the first sentence when the requester alleges that the agency is, but has not done so. Period. Okay. My experience in these kind of cases is this is not a case where you need expedition. This is a case where documents have been created, they are there, and the question is, do they have to be posted or not? If you want to get the document themselves, you can make a FOIA request for the document. You probably already have it. The question is whether they have to continuously be posted. So I guess I don't care about the 90 days one way or the other, but I don't think that's how these cases come up. As far as the rest of us is concerned, I think I agree that should be taken out. The FOIA standards on expedition and on fees and everything else. In most of these cases, there won't be any printing costs, because the question is whether they're going to have to be posted or not. So I think we're just better off saying nothing, and I think the courts and the agencies can figure it out. And so I would support taking out the second sentence and leaving it in there. And as far as how long the agency has to respond, I mean, the 20 and 30 days in the existing FOIA may not make any sense, but I think my experience is going to be in something like this. If the agency writes back and says, we're trying to decide whether you're right or not, nobody's going to sue them, because it's not whether you get a document or not, which is what most FOIA cases are about. It's whether something has to go up on the website, and there's hardly any urgency on that. It's a long-standing difference of opinion, and it'll be ironed out as they go forward. So I'm okay with that, with it as amended.
All right, perfect. Thank you, Alan. Burke, you started some of this. Can you kind of chime in? How's this looking for you?
You caused this problem. What do you think about this? Actually, I mean, I think I actually like the changes so far. I'm a little agnostic on the time frame for a lot of the reasons that Alan says. I think we'll figure this out, and it may be a situation where we have to go back and find things that are more than 90 days old. But in terms of the addition of the phrase when the requester alleges the agency is required, and then striking the second sentence, I'm in favor of.
Okay, is there anybody who defends the second sentence? I don't want to. I'm just trying to channel rather than like speak my own here. I don't even know enough to know. Would somebody like to defend the second sentence? Looking through for hands. All right, seeing no one's raising in the second sentence to defense, I think we will propose that to be gone. 90 days, does anybody have a different feeling about 90 days? Roxanne, or whatever. Roxanne, the floor is yours.
I don't feel strongly about even including the 90 days. I don't think it's super helpful here, especially if you get rid of the second sentence. I'd say
Okay.
leave it more generic and take that out.
Okay. Margaret or any of the consultants, do you have any thoughts on the 90 days or that idea, that concept?
Yeah, I think you know what you said, Aaron, at the beginning is right, that this is a more global question about compliance deadlines for the obligation. So I'm not sure that that proposal were you to insert it really belongs in this provision so much as it might be a separate recommendation about deadlines for compliance generally going forward with affirmative disclosure obligations,
Mhm.
as I understand Roxanne's concern. And so if you wanted to make such a recommendation, I think it would stand alone about, you know, proactive disclosure obligations under A2 must be met within 90 days of the creation of the record or something along those lines, which would, I think, address Roxanne's, you know, hypothetical about a newly created record and how long they have. I don't know whether you want to do that or not. It's not something we've studied or considered, so we don't have like a report that would back that specifically, but I don't think it's a bad idea. And regardless, deadlines for compliance are something that we did note would have to be addressed under any new statutory provision. We just did not take a position on what they should be.
Sure, that's the beauty of ACUS is we have so many experts here that even if the consultants didn't directly address it, we might very well have expertise on the committee. So let's just leave that as a placeholder there. Let's just finish up on 6. Does anybody else want to be heard on 6 as written on the screen? Alan, do you want to be heard on 6?
No, I was going to support Margaret and also point out that maybe we should say something about transition because there's not newly created records. For example, many of these records are in existence now, and we should and maybe we should just on this new placeholder 8, Congress should provide for transition, appropriate transition provisions for with both respect to existing records and newly created records that may come within the provision or something like that.
I agree. Speaking as myself as a committee member, that I agree. I think that's very helpful. All right, so 6. Does anyone else want to be heard on 6? I'm looking through, seeing no hands. All right, great, wonderful. And we're on schedule. That's awesome. All right, let's move to 7. All right, great. I'll give everybody a chance to read 7, and then I will ask Alexander for the pre-submitted comments.
We have one pre-submitted comment on current number 7. It's from Senior Fellow Alan Morrison, who just spoke so eloquently, asking about FOIA's time limit for requests for specific records.
Alex, not Alex. I'm giving Alan. Would you like to be heard on 7? Or would you please explain
No,
your
I mean,
comment
my
for us?
point is that the FOIA time limits are very short, and must exhaust I would just say must exhaust appropriate administrative remedies before filing a complaint, and just leave out the required by 552, and leave it up to Congress. I mean, we can't write this statute ourselves, and that will be the point is we want to make it clear that you have to exhaust administrative remedies, and how you go about doing it is less important, it seems to me, and likely to cause complications here and harder to draft, and not really the essence of our recommendation. We want to be sure that A, you can get them, and B, that you have to exhaust administrative remedies, and the details of which I think we're probably better off leaving to Congress.
Margaret, do you have thoughts on that?
Yeah, I'll note just that we did discuss this amongst ourselves at the time of formulating the recommendation, and concluded that it was better to use existing procedures than to open the door for potentially different exhaustion procedures between agencies, that a known procedure for making a request and exhausting administrative remedies with respect to it would be more comprehensible to the public. And also that, although the deadlines are short, the request is that they post records online, the agency post records online that should have been made affirmatively available but weren't, presumably a response saying, oh, we now realize that these should be, and we're beginning to post them, is going to keep a requester from litigating. So as a practical matter, I think you know, as Alan said, with respect to other matters, you know, the deadlines will not end up being sort of litigation triggers if the agency is responding to appropriate requests. So we thought it was better to use the existing procedures, but we do agree that exhaustion is important. So some other exhaustion procedures, so long as it was not overly burdensome and comprehensible to the public, is probably okay.
But your preference would be to keep in the 552 language.
That was our preference. You know, right now there are 2 circuits that have ruled that you can bring these kinds of cases under FOIA, and exhaustion has not yet been decided, but some requesters who have litigated those cases have in fact exhausted under those existing procedures, seemingly without issue. And so our feeling was, if it isn't broken, then don't look for a new bespoke solution. And so, you know, I could imagine, you know, something else that perhaps felt like it was tailored to the situation better, but if this one is working fine and everyone understands what it is, our feeling was to leave it the way it is.
If this was a class, I would just call on a student. I can't very well do that here, but could I ask a government member to chime in on this one? I confess this is beyond my expertise, but somebody who deals with this on the 552 specific question. If not, I can call on somebody, but is there a government member who would like to be heard on that, who deals with this all the time? All right, or we could do a straw poll here. I'm trying to get some feedback here. Usually if we're all in the room together, I'd be looking around at everybody's faces and seeing if they're nodding or not nodding. I have no idea where the room is on whether we want to keep 552 reference here or not. Margaret and Alan both have their hands raised. Let me give the government members one more chance and then I'll call on you. Is there I'm just trying to get a temperature of the room. Okay, all right. Alan, then Margaret.
Oh, I don't have any strong objection to keeping 552 language in there. If the government members aren't concerned about it, then I'm not concerned about it, because from an outsider's perspective, when I make a request, I'm not gonna sue within 20 days unless it's a really big deal, which is not likely to be in something like this. And the government will come back and say, we need more time to think about this, and the judge will give them more time. So Margaret's point about the procedures seem to be working, at least on the exhaustion point, unlike the stuff that we took out earlier about expedition and other things. I don't feel very strongly about it. If the government doesn't, the members don't feel strongly about it, then I certainly wouldn't press this.
Okay, Margaret.
I just wanted to channel my co-consultant who's sent me a message. I don't know if you want to give Bernie the floor to discuss it.
Sure, sure.
Okay.
Bernie, the floor is yours.
Sure. I just wanted to mention that the time deadlines for 552 come into play in certain situations where the government hasn't responded within that time period at all, and there can, in certain circumstances, be waiver of the ability to raise exhaustion of administrative remedies. And so I think it does have, that deadline does have significance in that context, which is not to say that current deadlines are the right timing or aren't too short, but it does, just the committee should be aware that there is some impact with regard to possible waiver of the ability to raise exhaustion.
So do you think we should keep the language? Again, this is just my lack of knowledge here. Does that mean we keep the language as it is, or does that mean we need to change the language?
I think there should be some deadline. If there's no objection to the deadline, the existing deadlines in 552,
Okay.
then I think that's what should be kept.
Awesome, thank you. Jen Dickey.
Thanks. I think this might be a me problem. I think I might be the only one with a little bit concerned about this, but one thing I wanted to raise on this one is that I'm sort of constitutionally skeptical and like concerned about any sort of creation of litigation in contemplation of the injury being informational only. That's an issue that's being litigated a lot right now in the courts. The Supreme Court has been like a little unclear about what it means to have an informational injury and like how concrete that needs to be. And this seems to contemplate pretty broad standing for like anyone to just bring a suit alleging that the agency has like not fulfilled its obligations. And I think just my own personal issue is I'm a little bit concerned about trying to use the courts to force the executive to do what it's supposed to do under the law when there's not, you know, a concrete particularized injury and when it's purely sort of an informational injury that's shared with everyone in the public. And so I don't know if there's a way to do anything with it. I probably would be more inclined to just cut this paragraph entirely because of that. But I think that I might be the only one who's concerned about that. I voice it because I have that concern.
Sure. So I'll put myself in the queue. I'm sympathetic to that concern. I'm not concerned about this particular paragraph, however, because this is only a question of statute. Nothing we say, even assuming Congress does everything exactly as we say, which they surely won't, that doesn't change the constitutional baseline. All this would be saying is, as a matter of statutory law, you know, you have a right to this, but you still have to satisfy Article 3 to get into court, and we can't say anything about that. So we're just saying, to the extent you have Article 3 standing, there's not going to be a statutory bar to you all, an additional statutory bar. I mean, does that take away some of the heartburn?
For me, I just think it's not good government for Congress to be telling the courts or the public that they can do something if the Constitution tells them that they can't. Like, it creates this weird confluence where like Congress says you should be able to get into court, and a member of the public might think, well, the Congress said I can get into court, and then they don't understand the like case or controversy issue. And so while I understand that that is how it would work in practice, I just don't think it's really good government to do that.
Okay. All right. Does anybody else want to be heard on that? Or something else? Let's do Jen's comment first, and then we'll ask something else. Does anybody want to be heard on Jen's comment? Looking through the list here. All right, hearing none. I saw your hand was raised, Burke, presumably about something else. Burke,
Yeah, sorry. Yeah, no, I'm just catching up to the prior discussion. If we're talking, what I was going to talk about was the exhaustion requirement, and I would actually include on reflection the statutory reference, because I just think it provides a framework that agencies would know how to follow.
Okay. All right. So it sounds like we all want 552 back. So I'm going to ask again, does anybody don't want 552 there? If so, now is your time to speak up. I'm hearing none. Okay. And it doesn't sound like anybody else wants to be heard on 7. I'm sympathetic, Jen. I mean, if you could come up with some language, we could say, you know, consistent with Article 3 standing or something, that language would be cut if this ever gets enacted. But if that would, you know, release your heartache, I'm happy to consider such language. Roxanne.
I just have one small suggestion at the end of line 107, where it says a reviewing court. I would suggest changing a to the. I'm just finding it a little confusing to say you bring it in district court and then a reviewing court can order something. It's like, isn't it the same court, or is this talking about sending it, you know, to an appeals court beyond the district court? I don't know. I just thought the makes more sense. Small thing.
Does anybody object to that? Okay. All right. Would anybody else be like to heard on 7? Okay. All right. Let's move on to the new 8 then. We're making great progress. I appreciate everybody's cooperation here. This is great. Let's look at number 8. This is the one that we proposed to deal with the timeliness point. We picked 90 days, which you all saw how the sausage was made on that one. So if anybody has a better number, I'm fine listening. I picked 90 days because I see lots of 90 days in the statutory code. Our consultants didn't study 90 days. So, you know, I guess first, conceptually, do people like this? And then second, assuming that we do we have a different number we want to put in? Alan Morrison.
I would take out the 90 days. I would say should be should strike the be made within 90 days of, and just say should provide for appropriate transition periods for newly created or pre-existing and pre-existing records, or maybe, or I don't know. I don't, and that will give, it flags the issue and doesn't try to get us into time periods, because the time periods actually may be different for newly created records than they are for existing records.
All right, thank you. Burke.
So I was actually going to speak just against it as a whole on further consideration. And the reason I think is because we have an existing A2, that the existing A2 doesn't include a time frame for proactive, the current affirmative disclosure requirements. And I didn't see a need to back end it in here. I'm a little more comfortable with what Alan is proposing, in the sense that it sounds like it's providing essentially like a as quick as you can or as appropriately as you can. But more generally, I just feel like this is a broader ranging change that would in fact change A2 significantly. And I don't know that we want to get to that point, or I'd prefer for us not to.
So I see Ted. I'm going to call on you in a second, Ted. Roxanne, I know this wasn't you yourself, but this is your agency that was kind of the impetus of this. What is your thoughts on that?
I'm kind of regretting that my agency's comment even caused 8 to be created. I mean, I think that they probably wouldn't want more limitations placed on them rather than less. I do agree that there needs to be some sort of transition period for pre-existing documents, but for the creation of new documents going forward, I think it's going to be so context dependent. It could be hard to ask Congress to set a standard for that.
All right, thank you. Ted Hunt.
Yeah, I'll just echo Burke's comments. I think this is a bigger question that has to do with proactive disclosure in general under A2. And so I just think it's best that we just leave this out. I recommend taking it out for now.
So if we were to take that out, there still is the question of what do we do with all, because there's two things. There's newly created documents, and there are pre-existing things that we're going to want put on the, made publicly available. Presumably, we want that to have some sort of timeline. I don't know if we want to come up with the timeline. Would that be something that could be covered in, any correspondence we send or the transmittal letter that we send to Congress saying we did not talk about how much time to give, but that's something you should consider? Would that make people feel comfortable with this? And then we just cut 8 altogether, or what? Again, this is not my field, so I just want just throwing it out there as an idea. All right, so how about this? I'm hearing that the agency that led to 8 doesn't want it anymore, and our other government members who are speaking prefer not to have it. If we were to get rid of 8, which also wasn't in the initial from the consultants either, would that cause anybody real heartburn? So is there anybody who's a defender of 8 as we have it? Alan Morrison.
Well, if we don't put 8 in there, then there'll be no transition periods, and I could sue every agency the day that the law is enacted with respect to their existing records that are not up online. I don't think that's appropriate. I don't think agencies should put to that. All we're saying is that Congress should think about it and do appropriate periods, and I think it's agency protective, but maybe I'm mistaken.
I mean, I hear that. I think we should say something somewhere, either in the body of the recommendation or in the transmittal letter to Congress saying, hey, there's a whole bunch of things that are already created that you should think about what an appropriate time for this law to go into effect is. I don't know if that needs to be in the recommendations, but I think the concept should be somewhere. So I guess I'll talk to Alan about this one. If we were to put that in the transmittal memo or in the preamble or something about the stuff that already exists, not the new stuff, would that satisfy your concern?
Well, it would be in the. I'd be less concerned if it was in the preamble. Others have raised with me, and I want to hope we come back to this, the question about what the office of the chair should be doing in terms of drafting the specific statutory language when we've gone through all of this. I want to think about that. So I'm not in favor of it in the transmittal letter. If somebody thought
Okay.
that it would be okay in the preamble, look, I think this is mostly for the protection of agencies. If they don't want the protection, that's their problem. Because it's good, because in the absence of something like this, they're going to be in violation of the law if it ever gets enacted.
All right, Roxanne. Thank you, Alan.
Yeah, I mean, I think maybe this is something that would be okay in the preamble, or as you suggested, Aaron, in a cover letter. I mean, it's because it's not just a transition, the identification of the transition period for agencies to start to comply with these new requirements. Also, to what extent are the new requirements retroactive or prospective only? And
fair.
so, that's also an issue. And so that's the sort of thing that Congress would need to identify as to what does it apply to and how much time does people have to get themselves in compliance. I think would be helpful, as Alan was saying.
So if we were to put that point in the preamble saying we have not reached consensus on that, but it's something that Congress should consider as they draft legislation. So let's not do a transmittal. If it was in the preamble, would that work for you, Roxanne?
Sorry, I gave a thumbs up.
Okay, all right, thanks. Alan Morrison.
No, that's fine with me to put it in the preamble. Roxanne said something that I wanted to be sure everybody didn't pass over. She said the question is whether these changes would be retroactive. I have always assumed from the moment we began these discussions that these recommendations would apply to what agencies have created before now. And it's not retroactive in any liability sense. It's just that they have an obligation to do something they didn't have an obligation to do before. And if I am mistaken on that, then we have to do something to make it clear that these proposed changes would apply to records that they already have created but have not posted before.
Yeah, I assumed that was the case as well, by the language that we've used, that if a document falls within the definition, it goes forward. So I also had not thought about it not applying to existing documents. That seems like a question for the consultants. What do you think, Margaret, and et al., the team?
We did consider this, but did not make recommendations in that regard. We had suggested that it would, I think our proposals encompassed existing records on their face, but we did flag in our sort of list of things that we did not make affirmative recommendations about, that there could be some categories where, or some subsets of categories where Congress determines that existing documents past a certain date old, if it was more than, I don't know, 10 years old. I'm making something up right now. I'm not speaking for the five of us, but that's something, that there could be situations in which, it was determined that adjudications from 50 years ago at a high adjudication agency maybe aren't, going to be, but also there's an escape hatch for that in our recommendations, where an agency could, by rulemaking, determine not to post those old records because they're not of value to the public. And so that may be the answer. But we did not go through and have a line by line conversation about, is there any subcategory in which there should not be application to existing records? We did talk about a delay, some sort of period of time in which agencies would have to get up to compliance, that would be important.
Yeah, I think that, I mean, I'll let the government member speak. I agree with Alan, and it sounds like the consultant, maybe not the consultants, but I agree that on the face of what we're saying, it would apply to things that are still, operative legal documents. So it's not prospective only. It would apply to everything that's an operative legal document. And I also agree with what Margaret said about, we have an escape hatch. We built that in here, that if they think that it's, for whatever reason, it somehow falls within the definition of what needs to be disclosed, but there's good reasons not to, there's an out for that. So I would be inclined to not suggest that it's only prospective only. I think the natural reading of the document is it applies to everything. And so I would prefer not to get into that and just let the document stand as it is, subject to, in the preamble, we put in something to the effect that we're not talking about what the period is for, to get up to speed. But that's me speaking for myself. Roxanne?
Yeah, that's fine with me. I think that I noticed that discussion in the report from the consultants about is it retroactive? To what extent is it retroactive? I think it depends on the types of documents. We have published board decisions that go back to 1935 and they're all posted on our website. But unpublished board decisions, we only have so many that go so far back, and we just don't have any more than that. So I think that's fine the way it is now. And so we don't have to get into that can of worms.
Alan?
Oh, on the escape hatch, I was looking at Margaret's on section recommendation 2. I'm not sure that very old documents, assuming that you have them, are within the escape hatch provision. As I read it now, it only applies to do not vary considerably in terms of their factual concerns or the legal issues they raise. I had suggested early on that we add the word including in there, so that, for example, the exception that Margaret just mentioned for very old documents, which you have them, but you don't, they're not useful, have to be put up. But Margaret, am I mistaken about the current language in the escape hatch? And should we do anything about it? Maybe not at this moment. We have to go back and look at it.
Let's look at it right now. I think that's a good idea.
I think that question was addressed to me. I think, one question is if, for example, taking Roxanne's example where there's sort of old unpublished decisions that are, I think, I could read this and say, these are repetitive and duplicative of things that are, already online, voluminous and burdensome to the agency to post. And as a result, we're going through a rulemaking to exempt them. I don't know whether, I certainly think you could add more specific language to address that particular situation of old records, or you could sort of, I think, kick this can as a small problem that down the road to Congress in case they want to take up any issue about particularly old records.
What do you think about Alan's point about adding the word including as just giving a little bit of wiggle room for the agencies?
I think we opposed that when we had that first conversation on the grounds that including meant that was just one of any possible universe of reasons. And that if we had other reasons we thought would justify using the escape hatch, we should specify what they are so that there's a standard and not any reason the agency thinks is a good reason.
Okay.
Any reason. So I think if this is one of those reasons you want to list, then perhaps that's the way to do it, as opposed to leaving it open-ended.
Okay. Would anybody else like to be heard on this? Let's go down to 8 again. It sounds like what we're going to do is we're going to take, unless anyone objects, let's take out 8. We're going to delete 8 as we have it. We're going to put that concept in the preamble at some point. So go up to the preamble. Let's put a pin in that saying we need to add that somewhere. Right there, it seems like a great spot for, however you want to describe the pin, pin from former 8 or something. And then let's scroll down to 2 again. Thank you. You're doing wonderful, Alexandra. Scroll down to 2 again and see if we are okay with number 2, given this conversation we've just had. And I'm just reading this to make sure, so we imagine we have a very old record that just has, I guess it's a really old document that has a unique fact and unique law. If that's the case, I actually think I would want them to disclose it if they rely on it. So I'm inclined not to include it, add an including there, because that's exactly what I think they should turn over. I think that Margaret is correct that most of the time that's not going to happen. Either it's going to be the legal issue is not novel. There's been intervening agency adjudications that raise the same legal issue that will be disclosed, or the factual context isn't novel. But if you really have a unique factual context and a novel legal issue, then I think I would want them to disclose that. Am I wrong on that? Maybe Roxanne, I can pick on you. You're my co-chair, Roxanne. What do you think about that?
Yeah, I think that the age shouldn't be the determining factor in terms of whether it's posted or not. I think that it's the importance, or even if it still exists. I mean,
Yeah,
we get a claim for old unpublished board decisions to post. We just have to say we don't have them anymore. Which is,
correct. And then you wouldn't have, and nothing in this recommendation requires agencies to disclose things they don't have.
yes.
Why not?
Okay, given that conversation, Alan, are you okay with not adding including to 2?
Yes, okay.
Ted Hunt,
Yeah, I'm just trying to think. I mean, I think this is kind of something unique to my agency. I'm a little hesitant to talk about it, but maybe there could be a situation where we might have some older decisions from 100 years ago, but that collection is very incomplete. And so if that were the case, it's almost misleading to try to go back and put those online somewhere, because it's kind of hit or miss what we can kind of find in our old files from the ICC. And so I'm just wondering, is there a way to include something in that sentence because the individual record is not very considerably in terms of their factual context or legal issues they raise, or inclusion of such documents would be incomplete and misleading or something like that? I don't know if that really works. Just the thought, because we have our agency is so old, and we actually, and I don't even know, I can't say legally what we take a position on, whether those actually are our records anymore. But there are things that are at NARA, a lot of that's at NARA, but there's just things floating around. That I know we have some older stuff, but it's entirely incomplete.
but do you ever rely on any of those?
Yeah. Yeah.
Okay.
I mean,
Right, then,
in a sense that,
yeah.
the ICC stuff that's the issue.
Yeah.
Is when the board was
Yeah.
created, we passed we just sort of, I think Congress may have even said, that prior precedent is binding upon our agency, the ICC precedent, or we may have just said it in a decision. I can't remember. That we were going to accept ICC precedent going forward. So that's kind of the rub. But
So I guess I don't know. I'll speak for myself. Then I'm going to call on Margaret. Speaking for myself, if you can rely on it, I think it has to be there. You know what I mean? Like, it's one thing if these are old documents and it's like historical interest, like an archivist. But if these are actual things that you could imagine being cited in a new order, like, I think they should be able to find them, and whether it's incomplete or misleading, well, that's up to the argument in an individual case, but the document should be there. Again, that's me speaking as a member, not as chair. Margaret.
Yeah, I personally agree with Aaron, but also wanted to channel some comments I'm getting from my co-consultants about the idea that an agency can simply specify on the website, that the universe is in fact incomplete, or describe which ones are in fact no longer operative, or in any other way frame what it's disclosing. So it can provide more context and information to ensure that it isn't misleading without, sort of withdrawing it from the public realm.
Ted, does that reduce your heartburn?
Not really. I think, just because I think for us to have to go back into these old files that we have some and try to pull out what are actually binding agency decisions that exist, that were created 50 years ago, 60 years ago, 80 years ago, that's a heavy lift for us anyway. So I'm not sure what our position would be on that. We might just assert that, I'm just speaking out of context here, but that these are not our agency records anymore. So we're not going to put them on our website, but that's something we'd have to debate. So.
Okay. So I guess I'm saying, like, do you want to vote on that language, or are you okay if we withdraw that language? That's my specific question to you.
Yeah, I prefer
ad,
to have, I prefer to
on
have that in there, but I can understand why their folks don't like that. It's a little open-ended, but.
Okay, let's call on a vote. I think why not? Let's have a vote there to see where people are. So here's the vote. Are people like 2 as amended on the screen? If so, I'm trying to think the best way to do it. Yeah, let's do yeas and nays. If you're in favor of what's on the screen, raise your hand. And do it online so we can count. Okay, let's see. All right. Okay, so I see 5. How many do you see, Alexandra? The numbers are changing on my in here.
I see seven hands
Okay,
currently.
7 hands. All right. If you would like to go back to the original 2 that we had before we added the, let's just say nay to my other vote. Nay. They said yes. You say no, which means we want to go back to how we had it. Okay, I'm seeing. All right, the yays have it. We will go with this this language on the screen. Good job, Ted.
Thank you.
All right. Okay. So I think we're done with. We're gonna get a chance. We're gonna go through all of these again. You know, the recommendations, but right now we've gone through everything. We've covered everything. So let's look up at the preamble. Let's go through the preamble. And then what we'll do is we will add that new section that we were talking about. So hopefully we can do the preamble about 20 minutes, hopefully maybe even less than that. And then we'll go through, everybody will get a chance to look at all the recommendations again. And then I want to leave, you know, the last half hour, if we can, to talk about OLC and presidential records. And then we'll take a vote. So I think probably the best way to do this is how I usually do it, is let's give everybody a minute to, and we'll go paragraph by paragraph. So let's read paragraph 1 here, and then we'll ask for thoughts on this one, and then we'll go to the next one. Jen, do you have your hand raised that you want to speak, or was that still from voting?
Yeah, I just had a question about that
Sure.
last vote. So can you go back to that language? Was the language you guys were approving inclusion would be incomplete or misleading? Because like the thing that I don't understand how including like by necessarily if you're like leaving out some documents, then it's also going to be incomplete. Like, I guess I understand inclusion of documents would be misleading, but I don't understand how inclusion of such documents would be incomplete is like a helpful suggestion. Like, obviously, then
Okay.
you're also making it incomplete. And so that's what I'm confused by.
All right, so that sounds like a fairly friendly amendment to get rid of incomplete and just go with misleading. Ted, you already won. What do you think? Ted Hunt?
Yeah, sorry. Yeah, I mean, I guess misleading is one thing that, again, what the concern is I have is we have a collection that's really, really, you know, hit or miss, and it's from 100 years ago. And I kind of go, I don't know. Does that mean that it'd be misleading if we were going to conclude that? Maybe, I guess.
I mean, we already had a vote. You already won. We could do it. We have another vote to get rid of incomplete. But if you don't have a problem with incomplete being left out, because misleading is what's doing the work, you know, that.
Oh, well, yeah, but I understand that this is grammatically, it may not be the right way to phrase it. Boy. Yeah, I mean, I'm not sure if I can come up with alternative
Okay.
language necessarily right now.
Then I think, I mean, we already had a vote on it. Let's keep that in there. We're gonna get a chance to look at all of this again. So Jen, if I can give you a little bit of homework while we're doing this, if you can multitask, if you could think of another way to phrase that, that would be helpful when we get back to 2, okay?
Sure.
All right, thank you. All right, let's go back and let's go back to preamble. So let's do this here. Let's give everybody, you know, a minute to read through paragraph 1. And then I'll say, like, if you have any thoughts that we want to add to it. By the way, just to be clear, usually preambles are much longer than this. This is deliberately short because of the unique nature of this project. So our preamble is not as fulsome as we've had on some of the others. And that's by design. All right, would anybody like to be heard on any points in paragraph 1 of the preamble? All right, I see Alan Morrison. I see no other hands. Alan Morrison, floor is yours.
So if we decide to put in anything about the presidential records, we need to put it back. We probably should put a record in reference in there, but I don't suggest they do anything now, just a kind of a reminder.
Perfect. Let's put a pin there. I agree. Let's put a comment. If we add presidential records in, we're going to put presidential records back in the preamble. Thank you.
Quite welcome.
Anybody else? Okay, all right, let's move into the next paragraph, which I can't imagine we have that much debate about, but let's see. So let's give everybody a minute to read paragraph 2, and we'll see if there's any comments on paragraph 2. All right, Jen Dickey, the floor is yours.
This may just be a style thing, but I don't really understand what the word effectively is doing. Like Congress could implement them through legislative action. I don't really know why we need the word effectively there.
I agree with you, but I'll see if anybody disagrees. Is there anybody? By the way, the preamble was not written by the consultants, so I'm not going to call on the consultants to explain the language there. Does anybody want to defend effectively? All right, effectively is gone. Thank you, Jen. Anybody else like to be heard on paragraph 2? All right, seeing none, let's go down to paragraph 3. Same process as before. All right, Jen Dickey.
I kind of think it should say identified problems rather than discovered problems. Like I have this vision of ACUS like with like acting like paleontologists discovering, unearthing problems. I think identified is better.
Yeah, ACUS is Indiana Jones.
Yeah.
I guess I don't know. I wasn't part of the consultant report. Maybe it was. Maybe we were in the archives. I don't know. But I like identified. Does anybody feel strongly about discovered versus encountered versus identified? All right. I'm imagining. I'm looking around the room. I'm seeing no objections. We're gonna go with identified. Okay, I'm looking through. Am I seeing? All right. This suggests, by the way, we're going through this very quickly, that our preamble was very well done. So good job, Alexandra and Jeremy. We appreciate that. All right, now I've jinxed us. Let's go to the next paragraph here. All right, let's do paragraph 2 on this page. Again, the same process as before. So Alexandra, I have a question for you. Who did the language about the nothingness recommendation? Why is that in red?
Yes, so that is actually that was, as we wrote it, footnote 7. We received a suggestion from Professor Morrison that was in the comments I sent out, I believe
Okay,
that was
okay.
Monday. He suggested moving it into the preamble above the line. So that's where I moved it. It doesn't necessarily have to go there, but I wanted you all to be able to visually see the suggestion.
Okay. All right. Would anybody, thank you. I appreciate that. Would anybody like to be heard on this paragraph? Ted Hunt.
It's just a small stylistic thing, and maybe there is no difference semantically, but there's in the middle, it says, I'm looking at the line, sorry, I lost it. 28, I guess, line 28. And would provide clear standards as to what legal agencies must publish and where they must publish them. I mean, most of the time we say proactively disclose instead of publish. Yeah, is there a difference in that, or does it make a difference? Maybe not. But I was trying to sort of consistent.
That is a question for the consultants. What do we think, Margaret?
I mean, I think publishing does, when you publish it, you are practically disclosing, but I still was trying to have some consistency, make sure we're not changing terms.
I want to make sure oh, sorry, Margaret, the floor is yours.
Apologies. I thought you called on me. Apologies.
No,
Go ahead.
I did, and then you weren't there, so I just was filling the space. The floor is yours.
The statutory language, I believe, says publish with respect to the Federal Register, and doesn't use the word publish with respect to A2 obligations, and most of our recommendations are with respect to A2. So I think, unless I hear any objection from my co-consultants in my side chat, I think it would be fine to change it to proactively disclose, which would be consistent with the statutory framework as it is with regard to the pieces that we're proposing to amend.
All right, wonderful, thank you. Renee Landers.
Thank you. I don't, if we're not, I'm going on to the next sentence, the one that now begins with however, and I'm not sure however is the right kind of transitional word that we want there. I would like it to be a little bit less like contentious, about, yes, we recognize the reforms impose some additional upfront costs. I think the next sentence should be more about, that the proactive disclosure of agency legal materials can save time or money, et cetera, is more, I don't know, it's kind of a value statement and not a contrasting thing to the costs. So I don't have particular language, but I wanted to raise that issue in case other people, had that concerns. I mean, it just seems a little bit contentious. At the same time, right? Exactly. That's good.
All right. Alan, I'm not skipping over you, but Shannon has raised her hand and we've not heard from Shannon. So I'm going to let Shannon have the floor and then I'll turn to you. Okay. All right, Shannon, the floor is yours.
Thank you. In that same sentence, I would suggest replacing can save with may save. I'm not at all sure it's going to be a time saver, which may or may not say anything about whether we should do it. I think that there are other benefits as well, but I'm not at all sure that is the necessary result.
I agree with you. I think sometimes it will, sometimes it definitely won't. So I appreciate that. Thank you. Alan, the floor is yours.
Well, all I was going to suggest is I think that this, what used to be in a footnote is now in the text and nothing in this record. I would suggest putting it in a separate paragraph. I don't think it relates to this, and I think it's important enough that we should underscore it by putting it in a separate paragraph.
All right. Does anybody have Roxanne? Yes.
Just quickly, I just wanted to suggest that perhaps we have the committee on style look at the sentence where we changed publish to proactively disclose, because now it's just a little awkward, but I don't think we need to wordsmith it here just because you're proactive. It may end up saying must proactively disclose them, whether published in the Federal Register, posted on their websites, or and then figure out what to say about elsewhere. Just they could, I think we have the idea there, but if it could just be finessed a little.
Does anybody have an objection to sending that to the committee on style?
Have the staff do it. Take a cut at it first, which is essentially the committee on style, typically.
I mean, yeah, typically that's, when we say committee on style, there is not actually a committee on style. What that means is that the staff will propose language and then it will usually go to the committee chair to make sure. And my rule has always been, if it seems at all substantive, I say no. That's not what we're going to do. It's got to be a purely stylistic matter. And I'm pretty, you know, I don't think I've ever betrayed that. I was certainly having it on purpose. So that's what we mean by committee on style. For those of you who haven't done this before, is we will let the staff, you know, tweak the language, and then it goes to me and Roxanne, and we will make sure that it's not a substantive change before we send it off to the council. So with that understanding of committee on style, does anybody object? All right, perfect. Thank you. All right. So we'll talk about I guess we can do both of these at the same time. Does anybody have any more thoughts on, you know, the paragraph we're looking at, and now also the standalone paragraph about that was the footnote? Jen Dickey.
I would probably like to see it scroll down a little bit, but I wonder if that new paragraph might actually go better at the end as opposed to before this recommendation should not be considered, like, because it seems to break up the discussion of the reforms it is suggesting. So I might think we
Okay.
get to the end.
Alan, it's your kind of thought. Do you agree with that? We got a thumbs up. Okay. All right. Well, let's look now at this recommendation paragraph, and then we'll look at the nothing in this recommendation paragraph to make sure it works. So everyone's take a minute on this recommendation should not be considered as an exhaustive catalog paragraph. Okay, would anybody like to be heard on that paragraph? Jen Dickey.
Actually, now reading this, I almost wonder whether this language kind of belongs in the middle of that paragraph before nor should this recommendation be read as superseding the conferences. And then you end with the strong point of like, until Congress acts, we encourage the conference to, you know, adopt, or agencies to adopt the best practices.
Is that also a thumbs up, Alan? All right. Does anybody object to that? Looking through, seeing no hands. Okay, that's now the language on the screen. Does anybody else want to be heard on this language? Or not, we need to figure out where we're going to put in that language that we said it's going to go in the preamble. But let's just look what we have here. Seeing no hands, let's go with this language. Now, we needed a pin for former 8 about Congress needs to consider timing. Where would we put that? Should that be the last paragraph? Just about thoughts on implementation, on how they're going to do it. So let's make a new paragraph, Alexandra. And then I don't want to just leave that committee on style, because I want to make sure everybody sees this language here. So does anybody who's really good at language on the fly? Alexandra's doing pretty good with all this watching her type at the same time. That's remarkable. All right, that is an awesome placeholder, and very well done on the fly, I might say. So thoughts on this language here as capturing the idea that we want. Okay, I'm gonna pick on you, Roxanne, because this originates from your team. What do you think about that?
Works for me.
Okay. All right. Anyone else like to be heard? Either I would call on Margaret, but I know that the consultants didn't didn't do this. So either government or non-government members, does anybody have objections to this language or helpful additions or something altogether different? All right, seeing no hands, we have made it through the preamble, and that was very well done, Alexandra. That was you have a future ahead of you, and like I don't know what profession will pay you money to write text on the fly, but if so, you can make a fortune. All right, okay.
Thank you so much.
Take a bow. Okay, so all right, we now are at 15 after the hour. We're right on schedule. This is going great. What we're going to do here is, well, let me ask the group. I think it's actually, I'm going to call an audible. Let's talk real fast if we want to do anything on presidential records in OLC. Let's do that here. We had already taken a straw poll, and the thought was that we're going to take it out. Alan has, asked to be heard on that. So let's give Alan a moment on OLC first, and then presidential records, and then we'll take a vote on that, and then we'll have the entire text in front of us of the recommendations, and we'll go from there. So Alan, can I put you on the spot? Can you
Sure.
talk about what the deleted number 6?
Oh, thank you, Aaron, for bringing this back up. I appreciate it. I feel quite strongly that OLC records are some of the most important records in the government, and they're not being made available on a regular basis. I think they're far more important because of their effect on the government-wide interpretation of the law, particularly Constitution, but sometimes statutory matters as well. And therefore, I think this needs to be addressed. I also recognize that we're at a very late time in this process, and there are lots of back and forths even within the notion that these records should be made publicly available and publicly disclosed proactively. And so let me make a suggestion. The suggestion is that we not take this up in this committee now, and that we ask the chair of the conference to schedule another meeting, another committee to look at the question of OLC records, where that would be the only thing on the table. And it would be a smaller committee. I think it's necessary to have a different ratio of government to non-government people in that, because the government people's views are pretty well made clear. And I think we need to have people on the other side and to consider what to do about presidential requests, classified. I would also think that it would be very important to have some kind of an index that made publicly available, so that we even know what records are there to make requests. And I would think that we should, rather than try to do it now and try to draft on the fly now and go back and forth, this was an important element of the consultant's recommendation, and it's been the subject of major disputes both in the courts and elsewhere, and Congress has been very interested in this over the years, regardless of what administration is required. So I would ask if we could, I don't know whether we can get a formal, whether this has to go through the council or everything else, but an informal understanding that at least this topic will be considered, and if it doesn't get taken up, it doesn't get taken up, and we'll figure out what to do. But I don't press it. I just want to be clear that by not including it in this thing, that the conference is not making a decision that this is not a worthy topic for its discussion going forward. So I don't have anything to say about presidential records, or at least I don't have anything right now to say about it. I just want to focus on this. And thank you again, Aaron and Roxanne, for letting me raise this issue again.
Well, we appreciate that. Thank you, Alan. I'm going to call on Chris. I want to make sure that Andy, is Andy still on? If Andy would like to be heard on that before, I don't know if Andy's still on.
Yes, I'm here,
Sure.
Aaron, and yeah, after Chris speaks or anyone else speaks, I would like to weigh in. Thank you.
All right, perfect. All right, Chris.
I'd love to hear from Andy first, if he's willing to talk first.
Okay. Well, I certainly appreciate Alan's willingness to not bog down this committee in a controversial and time-consuming debate. But you know, and I appreciate the sentiment of the suggestion to have a separate committee look at it separately. As he suggested, it may be something that has to go through the council. I'm not sure. So I won't be in a position to commit to doing that at this point. But I certainly will talk to people about it and think about it and study it here within ACUS. Talk to Alan, get you involved in the thinking, Alan. And if we can do that, I would have no objection to that. But a big caveat that I'm not sure we can do it, but we'll look at it.
All right, thank you, Chris.
Yeah, I would just say, there's no way ACUS is going to do a separate recommendation on OLC or presidential records. I mean, because you'd be targeting, it's just not going to happen, right? That's not how ACUS is. I don't know if I'm as fully as committed as Alan to have Congress. But if we're going to do anything on OLC, this is where to do it. I guess what I'm saying, it's either this or it's not going to happen again, because this is tucked into a much larger cross-agency approach. And I generally share Alan's view that OLC opinions should be more generally available to the public. I'm not sure what that drafting would look like here. I could imagine if we wanted to go down that route, it sounds like we don't, but I'll just say my piece that we could Congress could direct the Attorney General to set up a process for identifying, as opposed to making them all available online, charging the Attorney General to set up a formal process to make them more easily available online or something like that. Again, if Alan's not going to want to push this, I'm not going to push it either. But I do think that this is probably the only shot that ACUS would have to consider something with respect to OLC.
I mean, I'm putting myself in the queue. I'm not sure that's right. I mean, I think probably for proposed legislation to Congress, maybe it is, but I don't know why it has to be the case. I think OLC is a different animal than some of the other things that we're talking about. So I could imagine if the council was interested, I don't see a reason why we couldn't do it in a separate process. So you're checking realpolitik, like that wouldn't actually happen. I don't know if that's true. I'm not sure that's true. I think that'd be up to the council. And I just don't think we know. But so I guess let's do it this way. We had a vote before, a straw poll. Let's just, before we go further, let's just take an actual vote. Margaret, you certainly can be heard. I'm sorry. After Margaret's heard, let's take a vote and just decide. So we just know where everybody is. Let's take a vote on 6. Yes, Margaret.
I'll be very brief. I wanted to emphasize 2 quick points. One is that we spent truly an inordinate amount of time on this question, and didn't the 5 of us start with the same priors? And so we really came to what I think is my second point, which is that truthfully, this is an incredibly modest proposal that we've made because we haven't touched the exemptions. So OLC's position is that basically everything it does is exempt. I'm overstating it slightly, but very little, right? Only those opinions that are actually adopted by an agency sort of formally are not exempt under exemption 5. And so we thought that the minimum that we could do is to put OLC opinions in the category of things that have to be affirmatively disclosed if they are not exempt. And as a result, that might be, under current law, a very small universe of opinions, but that if they're not exempt, they should be disclosed affirmatively. And that if something were to change with exemptions going forward, either because of judicial decisions or because Congress does something specifically with respect to OLC or with respect to exemption 5, then that would change the nature of affirmative disclosure, because non-exempt opinions would have to be disclosed. But I don't think this does nearly as much as it might sort of startle on its face. And this was, we thought, an important signal that OLC opinions are important legal materials and should be disclosed when they're not exempt. And I think that's a point worth making, even if it doesn't have as much operative effect as everyone might want, or maybe it has exactly the operative effect people might want, but it doesn't have a huge amount of operative effect. So I just wanted to say that because of not touching exemptions, the proposal is, as we see it, very modest.
Okay. I said we're gonna have a vote, but I see Jen Dickey has her hand. Jen, the floor is yours.
I just had one comment, which is like the concern I have with OLC opinions, at least one of the concerns, is that I could imagine from my own experiences that sometimes a question gets asked that's like kind of a radical policy proposal, OLC bats it down and nothing ever happens with it. And I'm not sure how helpful it is in terms of encouraging the president to seek advice from OLC if they start to worry that OLC opinions like that never sort of amount to any actual policy action that's taken could potentially be disclosed. Like I can see a lot of fear from the president, and I don't think we would want to discourage the president from seeking that kind of legal advice. So that's just like one thing that pops to my mind as one of the reasons why I'm like cautious about the OLC thing.
Okay, so before we did a straw poll, let's just do an actual vote. So there's no confusion about the effect of this, an actual vote. And I'm not so good at coming up with these on the fly, but the vote is going to be if you agree that the language that is currently stricken should remain stricken, then signify by saying aye, by raising your hands. And remember, we only want committee members to vote. So if you're not a committee member, don't vote, because it's going to be really hard for me to keep track here. Okay, all right. Do we have the count, Alexander, on that one? Then I'm going to ask for the nays.
On that one, I counted 8, and they were all committee members. We marked the committee members with an asterisk at the beginning of their names.
Okay, thank you. All right, now lower your hands. If you think that that language should not be stricken, please raise your hand now. In other words, the inverse of what the vote we just had. Okay, that language stays stricken. All right. I guess we see a couple hands up. Let me make sure I give people a chance. It's 8-2, the language comes out. All right. Okay. Thank you, everybody. Now let's do presidential records. I know, Alan, that yes, Chris.
So I would just be curious, just for my own sleeping tonight. I did not vote in favor of the language because I don't think that language is the right language. But I would like to know whether the committee thinks we should address the OLC opinions in this recommendation at all. I don't know. I mean, that's what I would have liked to have voted on, just to know.
Okay, sure.
If I'm in the far minority on that, great, but I don't think I think most of us look at this language and think it would have to at least be tinkered with.
Okay, all right. Well, let me come up with the different language again. So the language of the straw poll was, should we drop OLC from the recommendation, or something to that effect? So I'll just say, anybody who is there anyone else in the Chris camp? I don't want to call for another vote. Is there anybody else in the Chris camp that if we change things enough, you might want to change your vote? That there's some variation of the language that would change your vote from a yay to a nay.
All right, thanks, Aaron. I think that's helpful.
All right, Erica, your hand is raised.
Yeah, I'm now confused about the nature of the vote. I'm sorry. The last little thing you said got me backwards.
Okay. So what I was trying to say very inartfully was we first had our straw poll 2 meetings ago where we said, all right, should we drop OLC? And it was a pretty overwhelming yes, we should drop OLC. I was trying to do the same thing here, and I inartfully, by reference to the language on the screen. So what I asked Chris, and now for everybody else, is there language that about OLC that you, if there was, how about I just say this way?
Aaron, the way I would have said it.
Thanks, Chris. All right.
So the way I would say it is, are there anyone other than me that is interested that thinks this recommendation should cover OLC to some degree? That's all I wanted to know. So, because I don't think any of us want this particular language, but is there anyone else on the committee that thinks
Oh, okay, this
it
is,
should
this is
include
what,
this.
this is what we're gonna do. I want this record to be clean. So when we go into the plenary, we're gonna take a formal vote, and the formal vote is going to be the same as we did for the straw poll, but now is a formal vote, which is, do we want all references to OLC to be excluded from the recommendation? Does that work for the language?
So,
Like
you know,
everybody-
should we want it
every-
out?
Yes, no OLC. Like if you vote yes, that means there's no reference to OLC in this recommendation. All right, I ask that people please vote. If you want all references to OLC stricken from the recommendation, please raise your hand. I apologize for being inartful at this. Okay. All right, I see the votes. Okay, you can lower your hands. If you want references to OLC to be in the recommendation, please raise your hand. Okay, all right, thank you. OLC comes out, but now everybody's clear. Erica, does that work? All right, perfect, thank you. All right, let's do presidential records. I know that wasn't, Alan said in his comments that it wasn't as important to him as OLC, but that still was a point that we did last time through straw poll rather than a vote. So Alan, if you would like to be heard on presidential records, you can have the floor. If not, I'll ask for someone else if they would like to be heard.
Yes, my only question was why this was taken out. I guess I didn't understand why. I mean, I know we're dealing with agency records, but these seem to be minor things that people have substantive disagreements, or was that we shouldn't be dealing with presidential records, or what was the rationale?
Would somebody like to be heard? I can speak, but I would like someone else to have a chance to speak if they would like to respond to Alan. All right, I'll put myself in the queue. My concern with the presidential record stuff is I think it gets deeper into the heart of Article 2. And I don't know if we necessarily want to dive into where the exact lines are as to how much Congress can tell the president what to do. And this feels maybe a little bit like I say, well, what about standing? You just said that. This feels a little bit different to me because this entire question, I wonder if there's any space for this at all. And I worry about, going off into Article 2 land, especially where the Supreme Court is right now, where all of that is in flux. And it just feels to me like a big can of worms and not really squarely within what we were trying to do. So that was my view, why I voted to take out presidential records. The Article 2 stuff, especially where the court is now, which is, unclear. And it just felt a little bit tangential to the other stuff that seemed a little bit more core to the project. So that was my view on that one. But if other people disagree, or if anyone agrees or disagrees, I'm happy to hear you out. Kurti, and then I'll let Alan have the floor again.
Yeah, can I just ask a follow-up question, Aaron, on that? Like,
sure.
Looking at the first example, and I'm recalling examples even from my time at OLC when it was hard to find all of the proclamations under a given statute, for example, because some were in the daily records, some were in the in other places. And I'm wondering if your concern applies generally, or whether you still have the Article 2 concern when the president's acting pursuant to statutory authority. Because I guess my instinct is if Congress is granting the president the authority and saying you have to act by proclamation, it can also say, and you should publish it in this manner.
Again, like I don't claim to be the expert on this. I still have the same Article 2 concerns for both. And I mean, just my own personal background on this. Again, I'm not the expert. Chris and I, we did, Collins v. Yellen at the court, and that was by statute. Like those are all authorized by Congress, and yet nonetheless, there's still Article 2 concerns that overlay it. And I'm not quite sure where the court is on that stuff right now. And it just feels to me like we're getting into deeper waters there. So that's my thought is it's not core to the project and there's just question marks. I don't purport to have a strong view on that, but I have questions. And that's why I'm like, why are we going there? But again, there's other people, like when we did the straw poll, there was a lot of other folks who had thoughts on that one. So if there's anyone who wants to speak, they can. I'll let Jen speak and then I'll let Alan speak.
Yeah, I just would echo your concerns. I think that you're setting up a conflict between the branches, or to try to loop in presidential records. Congress has always previously kind of stayed its hand with presidential records, I think for that reason. And I'm not sure why we want to be encouraging Congress to sort of invade the executive's prerogatives in that way. It's just setting up a conflict that's going to go to the Supreme Court, and who knows how the Supreme Court would, eventually resolve that. It might actually resolve it in a way that is less prone to disclosure generally for agency records. Like I think that it's just setting up a conflict we don't need. And I think it just does implicate a lot of analysis that I'm not sure we have really thought through or talked to all the different people, especially given the way different presidencies set up their executive office building.
Alan Morse and then Jim Tozy.
Oh, these recommendations all are to amend existing laws. In some
Yes.
cases, they're to clarify existing laws. I haven't seen any constitutional objections raised with respect to the Presidential Records Act, for example. In fact, it's been upheld. The Presidential Materials Recording Act, the predecessor of this. And so I don't think we're stepping into this. I agree that we haven't had a full debate on this, but that's not because of the inherent subject matter. I think some of these are actually going to be helpful to the president, and some of them are just clarifications of things that need to be done. Whether we have time to do them now in this limited period of time is a different question, but I don't see them raising any. I don't mean to say that there isn't a particular recommendation that might, but as a general proposition, if there's a constitutional problem, one would have thought that the Federal Register Act, which has been around for a long time, would have been challenged by the president, or a president would have told OLC that he has a problem with it. And as far as I know, that's never happened. So whether we have time to do it or not is a different question.
All right, thank you. Jim Tozy.
You're on mute.
Oh, Jim.
Try now. I'm sorry, we cannot, I cannot hear Jim. All right, Jim, I'm sorry. I'm sure it's great wisdom, but we can't hear you. So it's not there. All right, what we're going to do the same as we did with the OLC. We had the straw poll before. We're going to do this with a vote, and we'll decide if it's worth going further on. But we're going to do this now as a vote, not as a straw poll. How did we phrase, Alexander, how did I phrase the language before when the vote actually worked for OLC?
So you asked people to raise their hand saying I in favor of removing the provision. I
Okay,
believe was the
perfect.
phrase.
All right, that's how we're going to do this then. If you want to remove references to presidential records from the recommendation, please raise your hand. Okay, do you have the vote, Alexandra?
Yes, sorry,
Before-
have the vote. Thank you.
All right, lower your hands, everybody. And now, if you would like to not remove the references or presidential records from the recommendation, please raise your hand. Okay, all right, they stay removed. All right, thanks, everybody. I appreciate that. I appreciate your comments on that one. Okay, so now what we have is we have 20 minutes and we have the recommendations. I think on 6, I still see some red line. I think we accepted that, didn't we? So I want to go through, I want to clean for everything through here. I guess we had some pre-submitted comments. So can we go through those real fast? Just identify, I want to make sure we can get a vote by the hour. Are all of the red lines that we have here the ones that Alan pre-submitted?
Yes, I believe so at this point with the edit I just made to 6 and 7.
Okay, so what we're going to do is we're going to read each of these the same way we did with the preamble. We've already looked at these before. We've taken even some, votes or straw votes on these before, but I want to make sure that no one has any other concerns before we move forward. And as you do that, we're going to assume that Alan's proposals are accepted as the language. If you don't like them, we can change that as well. But that's what we're doing. So assume that the red line has been accepted. Read the recommendation, and then I'll open the floor to anybody who has last minute thoughts on them. Can you get all of one on here? Is that possible? Yes, you can. All right, so let's read all of one. This is the long one. And then we'll go to two and the rest of them through. So everyone take a minute, go through one, make sure you're okay with this. And if you would like to be heard, let me know. All right, I'll call on you in a second, Ted. Just going to give people another few seconds. This is a long one. Okay, Ted Hunt, floor is yours.
Sorry, I just had a helicopter over my house here, so it's noisy. I'm still having trouble with part B here because and I don't have a problem necessarily with Alan's suggested splitting of the sentence there. That seems okay. We still have this in the last part of this is starting on line 58. It says an advisory opinions that would apply. So I think by doing this, I guess it's okay because I guess my only concern is this whole advisory opinions language. It seems to be something that's separate from what the first part of B was talking about. It was talking about decisions not to enforce something against an individual entity. So that's one thing, but then advisory opinions where it just seems to be a different animal. So I'm still struggling with this whole paragraph, but
so is it maybe I'm going to ask Margaret. Thank you, Ted. I didn't mean to cut you off, but
no, sorry.
If we said, is the point of this advisory opinions generally, or these advisory opinions not to enforce?
This was not our drafting.
Okay. Well, you're a smart person. What do you think?
We had a very different formulation of this, which was much broader, and so the redrafting, I don't actually know what was intended because we didn't
all right,
draft
thank
it.
you.
I'm sorry, I really don't.
That's fair. That's totally fair. That's totally. I mean, I guess my thought would be that it's echoing what Ted is saying is that the point is these are advisory opinions about the scope of enforcement. So I think not advisory opinions generally. So I think grant an individual waiver or exemption and an advisory opinion about the scope of the statute that apply generally applicable or something like that. If we said about the scope of the statute, would that work, Ted? Or is that, or it might not be the statute, the scope of the legal obligation?
Yeah, I mean, I think that might help. But it may actually not be necessary now if the sentence is split up. I'm just trying to understand it. I mean, does anybody else have concerns about this? If I'm the only one that has concerns about this, then we can just let it go.
Well, how about I ask this? Does anybody have a substantive concern with this? In which case we should figure that out now. If it's just does it read right? We can leave that for the committee on style. So does anybody have a substantive? I think that as I read it, I understand what it says. I think I understand what it's saying. Is there anybody confused about the language that we have here? Roxanne.
I would have to say that went round and round at first with the first sentence because our agency, for example, has a lot of documents where we write to a member of the public and we say that we haven't found merit as to the charges that have been brought. And so the conclusion I came to was that that would not apply, that this sentence would not apply to that. This sentence is saying there's a legal requirement and we're not enforcing it. Whereas the documents I was thinking of is there's a legal requirement, but we have not found a violation of that legal requirement. So it's not that we've chosen not to enforce the legal requirement. We have found that the legal requirement hasn't been violated. So that's how I would interpret that language. So it wouldn't apply to the documents I was thinking of. I don't know if that's clarifying at all for you, Ted, or others.
All right, Ted, are you okay if we put a pin on that one for committee on style to make sure that they read, it makes sense?
Yeah, I think that's fine. Yeah, I mean, I actually think Alan's putting the sentence up makes it work better because then the second sentence is entirely dependent upon the first. And as long as it is, then I think it works. But
all right, perfect. Thank you, everybody. Let's go on to 2. We have 15 minutes. I want to make sure we get this. Unless anyone else wants to hear anything in 1. That was the only thing only hands I saw raised. Seeing none, let's look at 2. Same process as before. Alan Morrison.
I want to agree with Jen Dickey that I think that the words incomplete or are misleading or whatever they are, but they're not helpful. I don't know how the inclusion could be incomplete. I'm open to other suggestions, but I think misleading would include that if you put 1 in and you should put 2 in, that would be misleading. But I think.
Yeah. I mean, again, I'm putting myself in the queue as a member. I agree with that. I think misleading is the right language, not incomplete. But I asked Jen for some homework, so I'm going to ask if Jen has thoughts on that one. If not, I'll let Ted have the floor.
I think Jen just dropped off, actually.
Jen dropped off. Jen dropped off. Okay, Ted.
Yeah, I'm fine with taking out incomplete or I think misleading is probably enough for us to sleep at night. So
okay,
thank you.
Roxanne.
Oh, I was just going to suggest the alternative instead of incomplete. The word could be confusing because that seems to meet more what Ted was trying to get at, which is you put some decisions and not others, and that's confusing. It's not misleading, but it is confusing. But if Ted's okay with taking out incomplete, that's fine. I would say, Ted, your agency not alone in this. We would have a similar situation.
I don't know if we need confusing or misleading. So if Ted's okay with misleading and you're okay with misleading, let's go with misleading. All right, wonderful. Thank you. Anyone else want to be heard on 2? All right, let's go to 3. Again, same process as before. All right, anybody like to be heard on 3? Okay, hearing none, let's go to 4. Same as before, read the thing and I'll take hands. Four, looking around the room visually here, virtually to see if I see any hands or concern. All right, seeing none, let's go to 5. Can you scroll that up, please? Thank you. Anybody like to be heard on 5? Seeing none, let's go to 6. We already did 6 and 7, but I'll give people another chance. Let's do 6 and 7 at the same time because we already did those for an hour earlier today. So let's reach 6 and 7. I'll give everybody a minute. Looking around the room, seeing no hands. Let's go to 8. Can you scroll it up for us, please? Thank you. These are much shorter. These are easier to read. I like these more than 1. All right. Any other concerns on 8? Okay, let's do number 9, which I don't think we're gonna have any concerns, but there we go. Alan has concerns on 9.
Yes,
All right, take it, Alan.
we've done such a magnificent job of drafting these recommendations that the notion that we should give to the chair, office of the chair, the responsibility for redrafting them, proposed statutory changes consistent. I mean, what do we envision doing in this situation that we haven't done already? Of course, the chair should prepare and submit to Congress proposed changes, the proposed recommendations, period. I mean, does anybody tell us what else they would do? Obviously, they can have background discussion, but I don't think that the office of the chair should be tasked with the job of cleaning up our recommendations.
I'm going to call on Jeremy because I haven't called on Jeremy before. Jeremy, what do you think?
Sure. I mean, this was included because it's a model that we think worked well for an earlier recommendation on clarifying statutory access. I mean, in some cases here, there's some ambiguity has been purposefully left in. It's been left unsaid how this would actually be integrated as part of 552A1A2, for example. So what I would imagine is the office of the chair, Andy would convene a working group of members like we did last time to actually translate this recommendation into statutory text as a tool that Congress can then use to actually implement this. But that's the general idea.
Alan, what do you think?
I don't like the part about putting it to statutory text. I mean, we have what we have, and we've done a really good job, and I appreciate the going back over it several times the way we often haven't had a chance to do in the committees. And I think we're pretty well wedded to this, and I would not support changes in the statutory text.
I am with Alan here, seeing myself as a member. I think I would propose the conference's office of the chair should submit to Congress this recommendation. Is that a friendly amendment, Alan? Are we on the same page?
Yes. Let me just see. Submit to Congress this recommendation. Yeah.
All right, Renee.
Submit this recommendation. Yes, grammatically it's better. Thank you,
Yeah.
Alexander.
Renee.
So I have a question because I read that sentence 9 to put the recommendations in the form of the actual proposed statutory changes. I didn't read it as a substantive provision. And so I guess I'm just curious about what the objection is about.
Since I echoed Alan, I'm going to say what I think the concern is. The concern is that we work pretty hard on specific and precise language, and there's a worry that I'm sure not on purpose, but if you have another group of people work on it who weren't here for all of this, they could very well be some of the things that we thought that we all reached consensus on after 4 meetings gets lost in the translation. I think that's my concern. Is that your concern, Alan?
Absolutely.
I appreciate that, but at least if we keep it within the control of the conference, there could be a backstop to that problem. Whereas if we just send the recommendations to the Congress, and then it's totally out of our control about what the specific statutory, provisions might end up looking like. I mean, they might end up looking completely different anyway, but at least we could have some control over the front end of the process without just sort of ceding control entirely to what the people in Congress decide to do with it.
That's fair. My reaction is whatever we say about 9, the council is going to change it anyway before it goes to the plenary. So this is a little bit me kind of putting our spin on it when I talk to the council. The council is going to make council amendments that are the first thing that are addressed at the plenary anyway. All right, how about this? Let's take a straw poll, just a straw poll. Is it just me and Alan that prefers the modified 9, or is there anyone else that's kind of on board with tweaking 9. So if you would like, this is the actual question. If you want 9 as prepared before Alan and I offered amendments, raise your hand now. Okay. All right. Lower your hands. If you think that we should change 9 in some way, raise your hand. All right. Ted, would you like to be heard on that, or are you just raising hand just on a vote?
No, just a late vote.
Okay. All right. Well, we lost. Okay, so let's go back to the original language of 9. We tried, Alan. All right, there we go. Let's go back, reject changes on 9. And there we go. Now we have time for the actual vote. So Alexander, can you give me the magic words here, or even, call the vote?
Would one of the committee co-chairs or both of the committee co-chairs like to call a vote on the recommendation?
I would like to call a vote on the recommendation.
Does anyone second that vote?
Second
that
vote.
motion, I should say.
I second that motion.
All right, everyone in favor of the recommendation, please vote by raising your hand. All right, I'll give people another second here. All right, please lower your, did you get the vote, Alexandra?
I did, thank you kindly.
All right, please lower your hands. Anyone who opposes the recommendation, please raise your hand. And there we go, the recommendation passes. Congratulations, everybody. This was a harder process. Everybody did a great job. Thank you so much, consultants. A wonderful, this is by far the most extensive report I have seen in my time at ACUS. Thank you so much for that. Thank you all committee members for your pre-submitted comments and your very helpful commentary. We will see what happens at the plenary, but we are done now for the committee. Thank you, everybody. Roxanne, do you have any more thoughts you would like to offer the team?
No, I'm good. And thanks for running a tight meeting, Aaron.
All right, everybody, thank you. And we are done.
Thank you all.
Bye, everyone. Thank you.